His Lordship Justice William Etuguba, retired Supreme Court Judge. Brigadier General Moses J. Jeke Asante. My Lord Justices of the Supreme Court. My Lord Justices of the Court of Appeal. And my Lord Justices of the High Court. Honorable Ministers and Parliamentarians. Your Honors of the Circuit Court and Magistrates of the District Court. Members of the bar, the press, lecturers, law students, the clergy, relatives, invited guests, all protocols observed. A very good afternoon to you. I thank you all for joining me today to celebrate the launch of my maiden book. It would not have been possible without the assistance of a number of people, too numerous to mention. Nonetheless, my Lady Chair, permit me to mention a few. My wife, Lydia Sapon, has had to endure a lot of loneliness during my journey of writing the book, and had to single-handedly take care of the children to give me some space to concentrate on the work. I must admit that she had put in a lot of effort and sacrifice, which I duly appreciate. My Lady Chair, please indulge me to thank His Lordship Justice Jones Doche, who for a very compelling reason is not here with us today, for agreeing to write the foreword of the book for me. The beautiful phrases he used, such as, and I quote, a well-researched book, a landmark book, an outstanding book, a book masterfully and skillfully written, a living and authoritative scholarly work, and above all, by recommending it as a truly indispensable book to judges, active legal practitioners, academicians, and students, is very humbling and inspiring. I really thank Her Ladyship Justice Gertrude Tokono, also of the Supreme Court, for taking time off her busy schedule to edit the voluminous manuscript I sent to her that has produced this great book, for which we are here gathered to unveil. My next gratitude goes to His Lordship Justice Victor Ofoe. About 5 years ago, after discovering me, he inculcated in me the zeal to write legal articles for publication when he was the president of the Association of Magistrates and Judges of Ghana, AMJG. He has since been my inspirational mentor. And throughout the gestation period of this book, I would say he was my coach. At a point in time, when the frustrations and discouragements encountered on my journey to this destination were too much for me to bear, and thought of aborting the whole idea of writing this book, he gave me countless reasons not to give up. Whilst Justice Ofoe acted as my personal coach, my good friend and classmate, Lieutenant Colonel Lawyer Ernest Ewuameya, was like the assistant coach. We brainstormed together, and he actually offered very useful contributions that went a long way to enrich the book. My Lord Justice Chebafor and Mr. Jeremiah Cranton deserve praise for their respective roles in ensuring the success of this program. I thank the publishing team at Advent Press, particularly Mr. Osei, Mr. Fifi Kweno, Mr. Isaac Ewuku, Mr. Ni Odai Akotrab, Ms. Rutinyame, and Mr. Nkechi R. Onwaha for not only producing an excellent finished product, but also sponsoring this program. My Lady Chair, permit me to start my speech by quoting His Lordship Amuase Chijesi in a lecture delivered at a Deba of attorneys at the Accra International Conference Center on the 7th day of October 1989, when he was speaking about the changing nature of the law. He stated thus, and I quote, "Of all the transient things, law is the most ephemeral, likely to be revised, modified, or rejected in later years." You can find this quote at page 149 of my book. Our elders say, when the music changes, the dance must also change. Last week, in a chat with a friend whose father was a fisherman, he said, and I quote, "When I was a young boy, anytime my father mentioned net, I knew he was referring to something that was used to catch a fish. But now, if I mention net to my son, he will think I'm referring to the internet." We are all aware that on the 23rd day of December 2020, the Land Act 2020, Act 1036, was enacted. Apart from repealing most of the land statutes on land, it also introduced a number of innovative concepts into land jurisprudence in Ghana. Notable among them are the extension of the usufructory interest to cover non-indigents, provisions to curb the menace of land guards activities, bringing fiduciaries of communal lands to account, creation of customary land secretariats, the safeguard of common land for community use, restriction on the transfer of land by spouses in marriage, automatic renewal of leases, electronic conveyancing, cessation of vested lands by the state, and the divesting of prior vested lands. These and many more are some of the novel essential themes brought about by the Land Act, which I dedicated myself to navigate. What started about 3 years ago as a passion for delivering weekly articles for publication for the consumption of judges, lawyers, and law students took a different twist when I started dissecting the essential themes introduced by Act 1036. It dawned on me that Ghana would immensely benefit from my work if I devote a little more time to tackle some of the problematic provisions in Act 1036. The conception of that thought has led to the delivery of the new baby, essential themes in land law and customary law, which we are adoring today. My Lady Chair, the book is unarguably the first audacious attempt by any writer since the coming into force of Act 1036 with a fine-tooth comb which discusses the new land law with a microscopic eye on the sections of the Act. The approach of the book is in the form of well-researched articles that intentionally tease out the forward-looking attempt to reform our law. One provision which delights me most is Section 12 on land guards. Apart from it being made illegal, the legislature has provided for a fast-track approach to restrain persons who interfere with one's development of his or her land. It is common knowledge that generally an interlocutory injunction, as the name suggests, can be obtained from a court only after a writ of summons had been filed. The term interlocutory literally means in between the issuance of a writ of summons, and the determination of the suit. In effect, essential themes in land law and customary law, the law has been thoroughly analyzed to embolden lawyers to approach the courts for orders restraining persons who interfere with their client's land without necessarily issuing any writ, so that upon the grant of the order, that becomes the end of the matter, and there will be no need to pursue the case for a determination of the ownership of the land or related issues. With that door now open to land users, it is expected that lawyers will take full advantage of the law with the cooperation of judges to ensure that the era of harassment by unscrupulous persons who loiter around demanding digging fees from land developers in Accra and other parts of the country will come to an end. For this reason alone, I would entreat you to grab a copy of the book before leaving this auditorium. Do not make life or legal practice too difficult for yourself when you have the requisite resource available with you now. The book has also reconceptualized other land law principles and practices that were long established in the past, such as how a stew or a family litigates in court, the role of statutory declaration in land adjudication, subleasing or subletting without the lessor's or landlord's consent, forfeiture and re-entry. All in all, the reader will find that the book is for everyone. It is an easy read because it is not written in legalistic, complex language. It is written in a beautiful, humoristic style, so it can be read as a textbook or as a novel. It can even be used as a Bible study manual. Let me emphasize the point once again that with most of the customary land law principles contained in land law textbooks of the 19th and 20th centuries becoming dead letters by virtue of recent legislation, coupled with the depth of case law on the new Land Act to guide the path of lawyers and land users, this book inevitably comes as a reference source book for all who require some knowledge of land law. It is hoped that the book will serve as a nuclear generator of fruitful debate as to the proper construction of the provisions of the Land Act. Before I retire to my seat, perhaps I may have to set the debate in motion. What is the effect of the sale of land by a chief with the consent and concurrence of the minority of his elders? With the 2018 decision in the Appeal in Chief's case, I know you say it is voidable, but not void. But I'm sorry to say that it is now void. Further, in the book, I have explained that a sale of land by a head of family alone is no longer voidable. It is like the sale of land by a chief or occupant of a stew alone. They are both void. What is even more intriguing is that the customary land law principle, which requires the consent and concurrence of the principal elders of the stew or family, have been modified. All the principal elders are now legally required not just to give their consent, but to execute the instrument. With this, I refer to Section 69(8) of the Land Act, 2020 Act 1036. It states as follows. And with your kind permission, my lady chair, I read. A conveyance is deemed to have been executed by a stool or skin, or clan or family, if the instrument is executed by all, emphasis is mine, executed by all the individuals whose consent is by customary law and necessary condition for the conveyance to bind the stool or skin or clan or family, unquote. There are a lot more debate to be set in motion, but I can only end here. Thank you all for being here today to support this grant event.
Thank you very much, my Lord. And that's the review of the book. Do we agree? We will shortly have goodwill messages. Many have had very beautiful things to say about the book. His Lordship Justice Jones Doche, after doing the foreword, concluded by commending the book to us and then referencing that a quotation by George Washington that a knowledge of books is the basis upon which other knowledge is to be built. And so we all need the book to build our knowledge. I'd like to recognize the presence of Nana Obri Asamoah II Bonfa Webri in Ashanti. Thank you so very much, Nana, for making time to join us. There are some of us who are still in masks, so it's been difficult to identify people you know who even sit close to you. Let's also welcome Justices of the Supreme Court sitting right in front of us, Justice Gertrude Tokono and Avery Lovelace Johnson. Please, a round of applause for them. Of course, Nene Abayate. Thank you all so very much. Shall we now have goodwill messages?
Justice Eledi Oko Uduma, a High Court judge in the Gambia. I'm sending my greetings and solidarity to my learned friends, Honorable Justice Alexander Osai Tutu, a High Court judge in Ghana and who is on secondment as a High Court judge in Gambia. Sir, congratulations. You are a great judge. You are an erudite scholar, an icon. I've had opportunity to go through the wonderful piece you put down for our generation. That is the essentials theme in land law and customary law. We are so much grateful. The work is an edifice of legal documents. I must say, it is not only for Ghana, it is for the world at large. It is not only for this generation, it is for generation others to come. I encourage all of us, including my humble self, to tap from it, to read it, to make use of it. Thank you, sir, for what you have done. It is a great work. I am saying congratulations, no grace to the elders, and no feathers to the judicial week. Thank you.
Book will help improve efficiency in the determination of land and customary matters. And so it will be an invaluable contribution to the many efforts that are being made to improve access to justice, and to the efforts to build confidence in the administration of justice. It addresses pertinent issues and reminds us, for example, that the right to possession of land is not always synonymous with trespass to land. It reminds us that we don't question enough our attachment to Western interpretations of our laws, especially our land and customary laws. It argues in favor of the concept of joint bail to improve access to justice. It argues in favor of enforcement of prenuptial agreements also to improve access to justice.
Please, a round of applause for Justice Alexander Osei-Tutu's friends and colleagues in the Gambia, where he presently does his work. We will, at this juncture, like to have some remarks by our guests of honor, and then we'll have the official lunch before we hear the spontaneous music man give us another interlude. Please, His Lordship Justice William Atuguba will give us his remarks, and then we'll have the official lunch.
Illustrious Chairperson, distinguished author, Honorable Deputy Attorney General, distinguished ladies and gentlemen. Before I start, I would like to refer a preliminary matter of construction to the distinguished author to deal with. Because as soon as my name was mentioned, there was some laughter. Now, what do you think is the causa causans? Now, anyway, I'm really overwhelmed by the duty cast upon me to make remarks about this book and then to launch it. To confess, the book intimidates me because the load of learning from anthropology to English law to customary, constitutional, everything is so, I've never seen a book so learned as this. The meticulous microscopic scope of his learning is very daunting. He even refers to Section A, Question 1 of the 2016 Ghana Law School Entrance Exam paper, which posed the question, who is the allodial title holder of land in the northern regions? Among them, he lists Naba, that's the chief, the Tindana, that's his target. And then he says that he is sure that most of the students must have said it was the Tindana. His research goes even to social media space, where he detected some argument going on between lawyers and the public as to the effect of land guards and caretakers. Impression being given that after a long time, these caretakers could acquire adverse title to the people who put them there. And he had to debunk this at length. There again, it shows that his research is limitless. Going to social media and anything that has something to do with the law relating to land law, he picks it up and deals with it. Of particular interest is his treatment of the allodial title, as the very first chapter in the book. And after giving a resume of the nature of the allodial title in legal history, he comes up with his conclusion that the allodial interest is the mother of all interests in land. I recommend this as the most apt description of the allodial title. It means it gives birth to all other titles and interests. It's like the grown-up of Carlson, on which all other laws depend. He, however, takes issue on 3 grounds with the definition of allodial title under the prevailing act, the Land Act 2020 of 2020. The definition, he says, is not progressive. It also has some omissions and is provocative of litigation. The 3 principal criticisms of that definition. Now, his reason for saying it's not progressive is that the governing expression descriptive of the allodial title refers to acquisition in the past. It mentions acquisition by the state, by conquest, by prior discovery and settlement, gifts, sale, and so forth. But because the expression is used in relation to this, that these are the most by which the title may have been acquired. He says that, well, it's not progressive because it means it is not dealing with prospective acquisitions or current acquisitions of allodial title, but only looks to the past. But he says that there are other modes of acquiring the allodial title than what even Section 2 has stated, even in terms of the past. It refers to other modes like adverse acquisition by acquiescence, the allodial title. So at first, under common law, it was not envisaged that the allodial title could be acquired by acquiescence. Because writers like Darocha and Lodo and so forth say that it being the highest interest in land, it is inconceivable that another interest could supersede it. Any form of acquisition of interest could supersede it. Well, I must emphasize that land is one of the most technical areas of the law. Very, very technical. But I'm happy that he has taken the position that since the decisions of the Supreme Court, beginning with Gayhawk versus Hannah I see or something. I think that was decided in 2005 to 2006 Supreme Court Annual Law Report, followed by Jane and Musa Pako also. And then the one he quotes at length is Agosai versus Nene Kobi Tetechru, in which he quotes a passage from our judgment. And I'm sweating because he says that I said that the allodial title could, from that time, be acquired by acquiescence under common law as well as under the statute of limitation. Yes and no. As I said, land law is highly technical. Those who say that it is the highest and cannot be acquired otherwise than to remain in the original owner are similar to those who say that estoppel per se can never be the route for claiming title to land as an established title. But he quotes from an English case where the court said, yes, long possession and all that, the acquiescence and so forth, will not divest the allodial title of the original owner. But it says that, it ends up by saying that, but in effect, that's what it does. So, I feel healed by the semantics of that kind of reasoning, and support him in saying that, notwithstanding those technicalities, our position in Agosai versus Kobe Tetechru, 2010 to 2012 Supreme Court General Reports, is the most realistic and up-to-date statement. He now goes on to talk about some other legal issues. I'll mention them in compendium because time is fast spent. He lists out a number of errors, omissions, inconsistencies in most of the provisions of this act. They actually replete. For example, in defining land, or talking about the ownership of land, some provisions will talk about the stool, skin, family, clan, or group of persons. Somewhere further down the line, reference to some of these things, some of these owners is omitted. And yet, there are duties which have been spelled out in relation to them. The question is whether the omitted ones are also subject to those duties and qualifications. Of particular interest is the position of the Tindana. I had the misfortune of having to write the judgment of the Supreme Court on who is the allodial title holder of land or some land in the Upper East region. At that time, we were encumbered with so many constitutional cases, but the case had pended for long. So we said, all right, we have to dispose of it. So we had a conference. We came to the conclusion that it is the Tindana. Those of you who are not from the north, the equivalent is land priest or Wulomo. Wulomo. The Ga version of it. And now, I want to emphasize why a book like this should be of importance to every legal mind. I'm from the Upper East. And when I was growing up, I saw that the official court Tindana was performing certain rites in relation to land. Sometimes when there was a drought, the villagers would go and drag him on the ground to some shrine to make sacrifice. And they'll keep on dragging him until rain comes. That's all I knew about Tindana. But what his real powers were in relation to, I had no idea. So, although when this matter came up, I, with that background, felt that no, it should be the Tindana. But what was the quantum of my knowledge about his landholding powers? Virtually nothing. I went to school too early, from age 6, thereabouts. So, the customary setting was not what caught up with me. Luckily for me, there was a very good article in the Review of Ghana Law written by Professor Ashite Kote. And when I read it carefully, I was encouraged that his analysis was right, that is the Tindana who has the allodial title for on behalf of the communities of at least the Upper East. He has clearly shown that the whole of the North ought to be the same as the Upper East position. That is, the Tindana is repository of the mother interest. This is what I now use. Mother interest, which is the allodial interest. Now, before I saw that article, I suffered a narrow defeat in some land case when I was at the bar at Bolgatanga, because I was doing a land matter, and I was contending, trying to analyze and to impress on the judge that the chiefs had no authority over land there. But then the material at my disposal was very scarce. My opponents went and took a certain book which recounted the case of Azantilo versus Nair, where it was held that the chief, Azantilo, had capacity to litigate lands, title to lands within his jurisdiction. So upon this, the judge was swayed, gave judgment against me. I was very aggrieved, but I couldn't blame him because that was the authority available to him. But Professor Ashite Kote analyzed that decision in his article in the Review of Ghana Law, I think it's 1980, Review of Ghana Law. So I was happy to have seen it, and I followed his reasoning. And he said Olenu was wrong in thinking that that decision made the Oh, okay. All right. Hey, 5 minutes. All right. I thought that because the book is so learned, I ought not to give a shallow review of it. But I have 5 minutes. So don't blame me for telling this. All right. So if I hadn't come across that article by Professor Ashita Kote, I would have been very, very hard-pressed to decide that matter. There were other writings quoted by Jan, who was counsel. So I'm saying that academic writings can be very, very important. First of all, they make your research easier. Imagine the number of law reports. Take just the Ghana law reports over all these years. If you are to find the law on a point and you have to read through all up to even the Supreme Court judgments alone, I mean, it will be a very, very burdensome task. And you can hardly inform yourself adequately of the law because the decisions are so many. And it will involve reading them as they are reported in the law reports. They are long. But writers like this will refer to all of them in a composite manner and makes it very easy. Well, apart from this allodial title matter, he talks about certain provisions of the Constitution or of the Act, which can be unconstitutional. For example, the purported area giving some hand to the Minister for Lands and some other administrative authorities to double in the administration of land. Says if you look at the constitutional provisions, Articles 267, 167, thereabouts, all these, and you match them against these provisions, they cannot stand constitutionality. An area of interest is spousal property. He says Parliament was supposed to have enacted legislation to spell out spousal property rights, but they did nothing until the Supreme Court had to say that, all right, in the meantime, in Mensa and Mensa, the divorce case, the impression was that property acquired during the marriage was presumed to be jointly acquired and to be shared equally. I must confess that I felt uncomfortable when I heard this. I think I was on the panel, but I said, hey, this one. All right, another time, maybe you can always distinguish in the party. So, I don't think that, you see, Africans, we must always go the full length of whatever the whites are doing. You know, some of our own practices are backed by common sense. And realism. I'm happy that
see how the men are.
In subsequent cases, I think Patson and I was on that one. Then Finn and others. Subsequent ones, they sought to limit the wide scope of Mensa and Mensa. And particularly, some of them said, look, we cannot override Articles 18 and 12, which uphold fundamental human rights to individual property ownership. And so, yeah, because otherwise, why should I, by reason of amorous adventure, incur forfeiture, partial or otherwise, of my bona fide acquired property? But how lawyers suffer to make their money? You go and bring somebody who has not sweated much because of certain attractions. Now, I want to emphasize that fundamental human rights shouldn't be joked with. And I think this is the second time I refer to this anecdote. When we were in the law faculty, I was made to illustrious Chief Justice. Now, the ladies were accustomed to working together, and we, the men, too. Not quite together, but not also with the ladies. One day I was passing by, and she and Akoto Bamfu and I think Alote and another were walking. Then she particularly asked me my idea about women. So I said, oh, well, they are good for discotheques and the kitchen. Maybe I added some other thing, maybe not, but it was necessarily implied. from others. So she said, oh, come on, foolish boy. But I was most grateful because she gave me the opportunity to express my candid view about the status of women. You know, those days, I mean, we were youngsters, you would think in those terms. I was very, very happy that I expressed myself. So, spousal rights must be looked at, subject to Articles 18 and 12. It's not only substantive law that he deals with the procedure too. For example, the mode of bringing actions or defending actions by families and stools. He insists that under the procedural rules, CI 47, as amended, it is the head of family or the occupant of the stool as well who can sue and be sued. But long before that, those provisions were there in LN 148, 1954, legislation, I think. But with time, the courts enunciated the principle that, these are corporate bodies, so they can sue and be sued like companies. So whether a head of family came and suing as such, or it was just the name of the stool or family they entertained. But I said that's not correct. And I think that he is right. The courts cannot just overrule legislation. You know that procedural rules, breaches can be, waived and all that. Okay, they can go under that, but not just to push aside the provisions. And even there, when the waiver is given, the breach, the innocent party has to be placated in some costs. But that's not what has been happening. He also talks about the land guards can get injunction to protect any threats to your property and all that. But the procedure, is it by motion or by writ? He has dealt with them at length. There are many other things, but I think 5 minutes is gone. So all I'm emphasizing is that this book is most thoroughly written and is the most current because it's based on the latest Land Act. You cannot just, this is the best, most current book because whether you like it or not, you cannot hope to study the land law, the horse, the provisions of the Land Act. And he has based himself squarely on his analysis. And so when you read his book, you are well equipped as far as land matters are concerned when going to court or giving advice, whatever. This judge reminds me of some eminent judges of England, of Ghana. I'm sure you want me to start with Lord Denning, no? He came later. There was one particular judge at the High Court level whom even the House of Lords feared, Devlin. Very thorough, very brilliant. He is black, but I think some DNA may show some connection, genetic connection with Devlin, because he's of that stature. We also know of Lord Atkin. We know of Lord Denning. In Ghana, Apalu, Azukrab, and Co. are there. And it is fair for me to confer on him a praise that the English judges bestowed on Lord Macnaghten because of his learning. And they said that his name was one that was clarum et mirabile nomen. And so I compare that upon that note. I'm now going to launch. And taking a last ditch at his learning, which permeates the whole of this book and the purpose of today's function. He has made a remark that the earlier decisions under the common law, beginning with Ohimen, Ajay, Oleno, and so forth, spelling out the most of acquiring the allodial title, have been, the principles there have been somehow misconstrued or misunderstood, because he says Olenu did not exhaustively state them.